Back in June 2024, Director of Public Prosecutions Dismayed Green made pronouncements on several high-profile cases. Two of the most pressing included that of the police-involved shooting death of Reginald Shaw, shot and killed by police in Marshall on February 28, 2011.
To warrant the arrest and formal interviewing of the officers involved on suspicion of reckless manslaughter.
Similar pronouncements were made for the May 5, 2011 police shootings of the Viewfort Five, all shot by police during Operation Restore Confidence.
I find that this investigation is near completion, and the evidence emanating from the investigation in the further lines of inquiries as aforesaid is sufficient in my view to warrant the arrest and formal interviewing of the officers involved on suspicion of reckless manslaughter. I have advised the Commissioner accordingly.
Now, newly appointed Police Commissioner Verne Garde announced on Wednesday that new information in the cases of Reginald Shaw and the Viewfort Five has prompted a review, and both matters will be sent back for inquest to determine the circumstances of their deaths.
The matter with Reginald Shaw will be sent back to the inquest because of that additional evidence, and also the Viewfort Five will be sent back to an inquest because of additional information.
But the Commissioner's statements have been met with incredulity by human rights advocate and attorney-at-law Mary Francis.
I heard it last night and it was very depressing. I think it's incredulous. And gravely, it really depressed me to see that the new commissioner, I thought he was coming to bring something new to the table, would actually say he's thinking he has decided to write the Attorney General and ask them to reopen the inquest. I mean, it is just unbelievable and gravely upsetting to hear that coming from him, because I am saying, what is the fear? What is the concern? The best way to prove the police officers did not act unlawfully is to allow the matter to go to the court. The DPP has the function to lay prosecutions. The DPP receives evidence from the police. It took 5 years for the DPP to come up to the decision that he made June 19 this year, when he said he has advised, he has sufficient evidence, so much so to he has advised the commissioner, the former commissioner, that they should bring in the fellows, and because it warrants a charge of reckless manslaughter. I think that's what he said then. If the evidence which was placed by the very police before the DPP, and he found after going through the evidence that there was sufficient cause to merit that approach, why now the same police who were investigating and laid the evidence before, and they had all the files from the inquest of 2016 in the Viewfort Five, why is it that you're telling me, instead of following the advice, you are now going to go back to the first step of letting the police then having later information before another DPP? That's a waste of judicial resources.
Francis was unmoved by Garde's announcement of additional information in both cases that he noted warranted the inquests.
The Coroner's Act under Section 32 allows for a reopening of an inquest, but there are conditions and there are grounds which must be met in doing so. And he has not laid out the basis on which he came to his decision. I do not know his basis, but they have to fall squarely within the Section 30 of the Coroner's Act. And I do not see why he has to take that approach. It's a waste of judicial resources. It is 13 years since the killing. How the new evidence, if his new evidence, can materially affect the decision of the 2016 inquest, which determined there was unlawful killing, how can whatever has led him to that conclusion, whether it was new evidence or whatever, how can that affect the decision of another inquest? Right now, the best step would have been, this is outstanding, is to go through the courts, and if they are innocent, justice is done, they will declare them innocent. You understand? You cannot just, that is a way of continuing the immunity from suit, immunity from prosecution by police officers. And furthermore, I'm concerned because I wrote the chief magistrate, who is supposed to be a coroner, as to what is the status of inquest in St. Lucia. We had COVID, yes, and everything was stood in abeyance. But even before that, I had written her. We did not even know. What about Arnold Joseph, that was killed, the young schoolboy? Was there an inquest? We don't know those things.
According to the Coroner's Act 2008, Chapter 2.16, 32, Attorney General's powers in relation to inquest, number 1 reads, a person may apply to the Attorney General to have an inquest reopened on the grounds that new evidence has arisen or has been discovered after the conclusion of the proceedings by the coroner.
If that is done, the Attorney General must look carefully whether the conditions laid out in Section 42, he can do that if, in the interest of justice, if it is found there was fraud in the inquest, rejection of evidence, or some other irregularity. So unless those things are found, there is no basis for reopening, and that is not the way to go. It's a waste of resources, and that is a new round of musical chairs again. It has gone through 3 police commissioners, a new round of musical chairs. The DPP is the constitutional authority for prosecution, and I cannot see how the police collects evidence, gathers evidence, place it before the DPP for advice. The DPP follows advice you all, and then you're turning around, circumventing that, and then going to the AG. Want to go to the AG to ask for reopening? Certainly, that's not the way to. That's a misuse and abuse of the legal process.
The attorney at law called on the powers that be to revise the Coroner's Act to strengthen the nation's democracy and prevent the circumnavigation of justice.